gender and judging from an African vantage point. A different voice versus different perspectives. And the background of this paper is part of a larger project. It's part of my PhD, where I'm looking at the informal and formal aspects that influence women's appointment at the bench in South Africa and Zambia. And it was born mostly out of a frustration at the dearth of African material on this issue. Josephine mentioned earlier how the book she co-edited is the only book in Africa on gender judging. There has been some academic material written mostly in South Africa and very little. So it was the feeling of frustration coupled with inspiration I was getting from meeting many women judges. I've been privileged to have encountered and worked with a number of judges on the continent who are doing great work and wondering where their voice is, right? So when we read about gender and judging, it's mostly what's happening in Canada, what's happening in the UK, what's happening in Australia, and asking myself, where is the place for African women judges? Further, it was also saying, well, look, there's already existing theories, rationales around gender and judging, which Josephine mentioned earlier. So what can I contribute to this? And the first issue that I thought about tackling is this idea of women judging a different voice. So Carol Gilligan's book in 1982 was considered a breakthrough research because it looked at developmental psychology and talked about the fact that women and men reason differently. So the idea is that we have a difference in moral reasoning, and so while men are more concerned about the hierarchy of right and individualism, women are more concerned about preserving relationships. So we're more concerned about keeping the peace, and so we're likely to think a certain way and act a certain way. And people who were banting or advocating for more women judges jumped onto this, right? Well, they said, yes, we need to have more women judges because they speak differently. They're concerned about relationships, about peace. But this, of course, became problematic because it's been described as being essentialist, right? The idea there's an essential woman's experience, which can be isolated independently from race, class, sexual orientation, and other realities of experience. American Justice Sandra Day O'Connor said, it was funny because in the past we were told women shouldn't be lawyers because, you know, they're created to be mothers, to be in the kitchen. So there was a stereotype around what women were and why they couldn't be lawyers. And now we're actually permitting a stereotype of the type of women and why they should be judges. But also I asked myself, firstly, is there conclusive evidence on this? And there's been none. Research has been done and it doesn't show a conclusive evidence about a particular voice. But my second question was, if there was a particular voice, whose voice would it be actually? Angela Harris has said that when voices are silenced in order to privilege others, mostly those that are silenced are voices of black women. And Kimberly Crenshaw, a critical race theorist, also said that when black women have actually been excluded from anti-racist theory and from feminism because it's mostly predicated on a set of experiences, which black women do not ascribe to, do not reflect. So my question was asking, this voice, if there was a voice, where is the room for African voices? It either assimilates them into one voice, which is from the global north, because that's where the material is coming from, or it excludes them. There's no homogeneous narrative in Africa. Different Africans will tell you that. I mean, and I'm studying South Africa and Zambia. Those two countries, while they have colonialism in common, which someone referred to yesterday as a bit of our history, there are many different aspects in the two countries, right? So Zambia gained independence in 1964, has 73 tribes. We haven't had the history of racial segregation South Africa has had. I like to say I realized I was black when I moved here because I grew up in Zambia where the concept of being black and what that meant, what I could do, where I could go, what I could be, didn't exist. South Africa had apartheid to deal with. It's racially diverse. There are different challenges. So to say that even in the two countries alone, that there can be one voice, is actually very disingenuous. So then the question becomes, does the absence of a single voice mean that there is no difference women can make? And I'm arguing that the absence of a single voice actually points us to the possibility of different voices in judging, of various voices that can be helpful. So then the next question was then, what can these voices do? And because I work in judicial governance, I've been to many symposiums of judges. And every single workshop or conference, the one thing that is always in any program is judicial independence. Judicial independence is always high on the agenda. That is one issue where, irrespective of where you are, where you're based, people will agree you want a judicially independent judiciary, right? So you want a judiciary that is independent from improper influence, from inducements, from pressures, direct or indirect. And the idea that formal independence is institutional independence, right? So how your judges are appointed, how the judiciary as an institution is protected and strengthened. And then the substantive independence, which I say includes freedom from internal inducement. And here I say freedom from the baggage that we carry, because there are those who would say that a judge should be substantively independent and should only bow to their conscience. But my question becomes, what if this conscience is stated, right? What if this conscience is not a right conscience? Dugard talked about the idea of an articulate premise. And these are hidden agendas that play a role in judicial functions. And they arise largely from concealed factors. So unfortunately, here in South Africa, one of our judges sitting on the Gauteng bench, Judge Mabel Jansen, was outed, right? So there was this communication she had with a journalist over a certain period of time. And basically the crux of it is she was saying that black culture, rape is part of black culture. She said that in black culture, gang rape is not a biggie. Mothers tell their daughters, your father should be your first. She went on to say that she's yet to meet a black woman who hasn't been raped at 12, by the time she's 12. So when this information is out there, there's a big hoo-ha. And I found two things interesting. Firstly, that people were saying, how could a judge be thinking like this, right? So the assumption was, as a judge, the minute you say, I'm taking the judicial oath, no fear, favor, or prejudice, that everything shed, all your life experiences, everything just disappears. Yet we're situated characters. We're human beings, judges are human beings. The second interesting thing is that she herself said, but what's wrong with what I said? This is what I see in my court. All the cases I get about rape are these black men. In fact, she says the journalist has destroyed her life because what she said was made of what's happening there. And I actually spoke to a few judges from her court, and one judge, black judge in particular, was saying she personally was offended because she thought to herself, has my colleague been walking around here thinking my father was my first? Has she been walking around thinking that all black women judges in this court have been raped by the time they're 12? So that to me was a typical example of the fact that people don't shed their baggage when they come on the bench. And that assumption that they do is actually quite dangerous. So where does this fall into judicial independence? Judges apply legal doctrine using their own interpretation of law. The beauty of diversity, I argue, is that you are forced to be around the other. And in the courts, women have been the other, or outsiders, for so long. So if you think about it, even just our daily interactions, be it with your friends or your colleagues, there are times you've come up with an idea or read something and thought, this is the correct answer. You speak to other people, they give you different views, and you're like, maybe I'm not so clever, and maybe that's not correct. So what I'm arguing here is that diversity will expose different judges to each other. And this exposure starts to get people thinking about what their thoughts. As Kate O'Regan says, it starts to get people thinking about, let's say, their prejudices that are masquerading as common sense. Because our common sense individually is built on our situation, right? So we're situated actors. And I argue that this is not just possible on an appellate court, right? This is not just about, okay, the argument about deliberative arguments, where a diversity means when you're sitting on an appellate court, you can have these discussions. It's even in courts where people sit alone. It's who you mingle with in the tea room. It's who you're around. An example I'll give is one of our judges forums we had this year, and I was sitting on a table with 4 women judges. One were what would describe in South Africa as black, one was white, sorry, and 3 were black. And there was a discussion about how they've realized that lots of women who are involved in customary law marriages are actually in a very precarious position, because even though there's been a legalization of customary marriages, most women don't know that. So the issue only comes to being when the husband dies, and there's an inheritance issue before the courts, right? But what has been noticed is this then family members are coming with another woman and saying, no, this is his wife. And you'll find the wife, the original wife, saying, no, we had a discussion, the parents came to my place, the brothers came to my place, and there was a negotiation and discussion, and this is denied. So the white female judge then said, in court we always have witnesses denying each other. This is normal, she's seen it happen, it's sad, but it's normal. But it was interesting that the other judges emphasized to her that it's not just about denying and saying, I wasn't there, right? In these communities, the discussions, the family engagement is part of a bigger picture. So when you're denying, for example, Tabeth as John's wife, you're denying Tabeth's family who came to have these discussions, who came to, there was an exchange of money or gifts, but you're also denying my identity. Because when I'm married into John's family, I'm known as wife to John. In that community, I'm known as the daughter of that house. So once you deny me, it's not just about inheritance, you're denying my identity in the community. And she had never thought about it that way. So that was very interesting to see her think through this and think, okay, so I'm going to try to approach this differently. So then I connect that to impartiality. So my argument is that you cannot have impartiality without being substantively independent. I argue that substantive independence is the internal process, right? But I believe that impartiality is the manifestation of. So impartiality in practice means that a judge does not predetermine a matter or decide based on a particular affiliation for either party. But it is not absolute objectivity. It is having an open mind as opposed to having a blank slate. I argue that while impartiality is an external manifestation, it is not simply a matter of being blank. So it's not like Clarence Thomas suggested, being stripped down like a runner and being free of one's ideologies. Because as much as jurisprudence taught us that judges are objective, neutral, dispassionate, that can't work. Justice Yakub said that, judges are human beings and they judge human beings. So to expect them to be exclusively objective is actually a fallacy. What we should be looking at is asking our judges to try and be open-minded. Minnow refers to it as being open to being surprised, being open to different perspectives. And I argue that having women on the bench allows for this to happen because, like Josephine alluded to earlier, it allows for you to not just ask the question of, well, why does this woman who's being abused by this man take him back? Well, why do women who say that they've been sexually violated still go back? Or why do they wear these clothes? It leaves room for different types of women from different backgrounds to explain, to say, actually, where I'm from, what you might think is an abhorrent community practice is actually the way people have created social relations. It's respected, it's a norm. So while legally it might not be recognized, doesn't make it irrelevant or incorrect. And I think that's been a particular aspect that I've been concerned about is the idea of who's determining what's correct. Who's determining what is the notion of right and fair? If a community lives and functions by a certain way, are we in the position to say, no, that doesn't work because according to the law, this is what should happen? And interestingly, there's been a backlash against, I call PDP, previously disadvantaged persons, being on the bench, right? So the idea of them bringing bias. There's been a backlash against judges and women of color, and one of the most famous cases is R versus RD in Canada, where a black female judge made the comment that it is common in communities, especially black communities, for white policemen to arrest black men, even though there's been no real altercation. And they actually applied for a recusal. It went all the way up the Supreme Court, because the argument was that she's made that statement, she cannot be impartial. There have been many around a female judge being too feminist. Recusal applications have been brought against women sitting in sexual harassment cases because the idea is that, well, they're women and this sexual harassment case is brought by a female complainant, so they can't be objective, clearly. There's been no questions around, well, if you have a man, might this man not be biased towards the person who the complaint is made against? And so Graycar says that we have these accusations of biasness, basically, because whiteness or maleness are not viewed as impediments to partiality. So basically, whiteness or maleness is the standard, it's the norm. Anything that falls outside of that is then questionable, right? So can we trust this? Basically, it comes down to that. Can we trust that they will do the right thing? So the issue then becomes not so much the principle of impartiality, because that we'll agree on, but it's the application of impartiality. If we agree that legal doctrine and law has been male-created and dominated, then the application of that impartiality itself is tipped towards a certain paradigm. So when questions are asked about women being too feminist, or can we trust them on a sexual harassment case, what you're actually saying is these women don't fall within the norm, don't fall within the restrictions of impartiality and law. Can they be trusted to do the correct thing? And finally, I conclude that women on the bench can make a difference, but not because they speak with one voice. I argue that it is because there is a polytonality of voices, a variety of voices, that can challenge, colleagues thinking, and it goes both genders, around preconceived notions. And that too can feed into impartiality, the external manifestation, how you see litigants. And I also emphasize that it's not only about the outcome. So the outcomes may not change, right? So you won't necessarily have more cases being decided in one way, but the process of getting that outcome is also important. How you get to an outcome, how it's reasoned, how it's debated, and how litigants are treated when they appear in court, how they're listened to, because listening also is especially difficult when someone has got something to say that you don't necessarily agree with or have never heard or aspired to. So I argue that substantively independent judges are impartial judges, and that makes a stronger judiciary. And like I mentioned before, this is part of a bigger project, so I'd be very interested in hearing your thoughts. And on that note, thank you for your time.